Hey Harsha, what exactly is preliminary inquiry or what exactly is 173 clause 3 of BNS?
So 173 clause 3 of BNSS clearly states that it gives a power to police to do a preliminary inquiry before investigation or filing a FIR. So this clearly gives the discretion of the police, that is to the police officers, to clearly look into the case whether it forms a prima facie case. That too, this should be done within 14 days period. And this power is clearly with that of the police officers who are investigating this case. This is done to stop any frivolous cases or any cases which are done either as a vengeful one or either to harass the persons against whom the cases are filed. First, let's understand the basic process of any criminal proceedings. So, the first step will be registering a complaint. After registering the complaint, you will file the FIR. After FIR, an investigation takes place, and after investigation, the police completely reports this in a report known as police report according to BNSS and charge sheet according to layman language. So after this, the trial take place. So exactly this preliminary inquiry will take place at the stage of FIR filing. So the police will clearly check if there is any stance or this makes a prima facie case. Technically, it wasn't there in CRPC. It was never explicitly explained in CRPC, even though it was given out in various judgments. So it is a new addition in BNSS. But before this, the court has clearly stated that preliminary investigation or inquiry is allowed. So, in Lalita Kumari versus Government of UP in 2013, the court clearly stated out that there needs to be a preliminary inquiry in the following circumstances. The first is in marital cases, the second is in commercial disputes, the third is in medical negligence, and the fourth is in any corruption related disputes. And the final one is when there is a delay, which is a prolonged delay, and there is no proper reasoning for that, preliminary inquiry can be done.
The first one being King Emperor versus Nazir Ahmad Shah 1944, wherein the Privy Council held that the police is free to conduct a small preliminary inquiry at the start of the investigation and the judiciary should not interfere while the police is doing this. Ideally, the police functions and the judicial functions are completely different and not always overlapping, and the judiciary should respect the boundaries and let the police perform their functions. The second important case law in this aspect is Ramesh Kumari versus NCT of Delhi 2006, wherein the Honorable Supreme Court said that if the police officer investigating the case or noting down the case has a doubt in mind whether to register it as a cognizable offense or a non-cognizable offense, then it is justified in a way to conduct a small preliminary inquiry or an assessment or a fact-checking assessment in the beginning. The third and the most important case law in this aspect is Lalita Kumari versus Government of UP 2013. In this case, this was a 5-judge bench and which laid down the principles regarding the registration of FIR and police inquiry. The first principle that was laid down here was that whenever a police officer receives information regarding the commission of a cognizable offense, it should mandatorily register an FIR. There is no discretion for the police officer. If the police officer wants to check the genuineness or the veracity of the FIR, this is a post-FIR stage. But the registration of FIR is mandatory. The police cannot do it before the registration of the FIR. However, there are certain exceptions, as my friend has mentioned, and these are more or less civil related cases like matrimonial cases or some other civil cases. And another principle that was held by the Honorable Supreme Court here is that if the police is conducting a preliminary inquiry, it should ideally be done within 7 days, and at max it could be extended to 15 days with the permission of the judicial magistrate. As such, the addition of police inquiry in the BNSS is a powerful tool given to the police or bestowed upon the police in order to prevent the registration of false, frivolous and vague FIRs. However, it should be ensured that this does not become a tool for misuse for the police, preventing the registration of even genuine FIRs.